Hi Steve, thanks for getting in contact. I received a letter, attached, from Ben Carroll MP's office a week or two ago saying my query had been referred. Could you tell me a bit more about your role at WorkSafe and how this hot potato ended up in your lap? I'd be happy to send through a transcript, or I can run you through what I hope is the final, succinct, word on the matter from my end. Might be better, easier to understand. So here goes. Timeline. 2007, commence employment. 2011 injured at work. January 2013 sacked due to incapacity and absence beyond 52 weeks. November 2017 ex-employer provides current payslips showing accrued LSL hours but states no entitlements so due to dismissal. June 2018 ex-employer provides current payslips showing accrued LSL hours but this time isn't sure refers to payroll also not sure asks HR who relay a verbal message back to payroll who writes no entitlements to LSL after termination. The 30th of June 2018 start asking questions elsewhere and researching topic. July 2018 obtain contact details for HR who I've been arguing with ever since. Who's in charge? LSL matters are determined by FW Act or FW instrument. When there's no provision in law or instrument it falls back onto the LSL Act itself. Depth of DEDJTR are the statutory authority. There's a Victorian Wage Inspectorate who also has statutory authority and decision-making powers. The judicial authority is the industrial division of the Magistrates Court. From what I can tell Mr. Ben Carroll MP is the head honcho. The FW instrument, EBA. An EBA does not provide for instances where the exclusion in the Disability and Discrimination Act has been the basis from where the termination of employment has derived. An EBA will provide for a process where an employee is sacked on the grounds of misconduct, retirement and resignation. In these scenarios where employment ends, any accrued LSL that has not been used is to be paid on the date employment ends. An EBA may provide for an LSL entitlement for a specified service period to be paid when employment ends. My EBA has a service period min of 4 years. LSL is calculated at 1.3 weeks per year of employment if employed longer than 4 years. The termination payment an employee receives is the final step in a process the employer has agreed to follow when ending employment on the grounds outlined in the EBA only. When the worker's employment ends due to incapacity it is by a different process set out in legislation not the EBA. The final step in a dismissal process, termination payment, outlined in the EBA does not apply by default in the case of termination due to incapacity. This step can't be tacked onto the end by default because the previous steps in the dismissal process are not covered by the EBA and the relevant law does not direct it. The FW Act. The FW Act refers to LSL accruing whilst injured on and receiving compensation if the respective scheme allows, in the absence of reference to the accrual of LSL in the scheme's legislation at CS. The compensation law must state LSL does not accrue while receiving compensation payments otherwise we are to interpret this section of the FW Act to mean LSL continues to accrue. The Work Act only makes mention of LSL once Section 174 regard not to be had for certain contracts etc. says Workcover weekly payments aren't affected by taking or paying LSL. The LSL Act 2018. Here is a link to the repealed LSL Act 2018 which comes into force on the 1st of November 2018. http://www.legislation.vic.gov.au/dominO/WebFundScore/LDMS/EE6658366CB0CA256DA40837F6B/108500110D68B/$58115BS1.docx. Sections 12, Section 13, and Section 17 all contain provisions for injured workers. I think the most important term used in these sections is, even though in a strict legal sense it could be said that the employee's employment was interrupted. Yes, in a strict legal sense an injured worker's employment is interrupted upon termination but this should not break the continuity of employment while a worker is absent from work due to injury. There were only two main changes in the current and repealed Act which saw a change in the accrual of LSL for workers on maternity leave. The repealed Act also saw the inclusion of penalties and gave the statutory authority new powers to charge employers who refuse to pay or dick around with employees' LSL entitlements with a prosecutable offence. The statutory authority. When I made my initial inquiries to the DEDJTR and BusinessVic I got the standard contact WorkSafe response. I sent an obligatory email to WorkSafe who, as expected, confirmed the above. The next standard advice sent was to ring FWA. They also confirmed what I've written above. The DEDJTR then sent me a recently updated comprehensive guide to LSL in Victoria. Please see link. http://www.business.vic.gov.au/hiring-and-managing-staff/long-service-leave-act-continuous-employment. My interpretation is that LSL continues to accrue whilst off due to injury and receiving work cover benefits at a reduced rate of 48 weeks per year. Again, there is no mention of this stopping when employment is entered. The Victorian Wage Inspectorate. I cannot find any contact details for the newly appointed Victorian Wage Inspectorate that I heard is also investigating complaints about employers who withhold LSL entitlements, who also has the authority to determine LSL matters. The LSL Portability Bill 2018. During my search for info on the topic, I found the LSL portability bill. Although industry specific, you'd think what's clearly stated in Section 7, what is a service period, Part 3 would apply to all workers. http://www.legislation.vic.gov.au/dominO/WebC/C/B0CA258256CB0CA258256C3/DOLA-SIGN-file/5814568/1C716C3/slash employers need to keep in line with anti-discrimination laws CFW laws CFW Act Section 351 and Disability and Discrimination Act Section 17. http://www.osli.edu.au/legis/cth/num_at/f_WA209114/S351.html and http://www.osli.edu.au/cgi-bean/viewdoc/au/legis/cth/console_at/dda1992264/s15.html. Injured workers can be dismissed under Section 21 of the Disability and Discrimination Act, and it is not considered to be discriminatory, but this section can only be applied to not being offered a position or promotion. See http://www.osli.edu.au/cgi-bean/viewdoc/au/legis/cth/console_at/dda1992264/s21a.html. My interpretation. My position is it is not an act of discrimination when an injured worker's employment is terminated. It is the employer exercising their workplace right. When the employer exercises their workplace right, it cannot adversely affect a person with a disability. Denying the injured worker's workplace right is an adverse effect of the employer's action. This means that the injured worker's disability becomes the reason for the dismissal, which is okay, as well as the reason they are denied the right to accrue LSL, not okay. Seems though employers are not exempt from discrimination law relating to LSL accrual, their action has adversely affected the worker and they have discriminated against a person with a disability. Ex-employer decision, no entitlement. My guess is that an employer denying an injured worker's LSL entitlements hinges on Section 12 Part 6, as it provides for a few scenarios where a worker's employment is terminated and the continuity of employment is not broken. This part, although referring to certain scenarios where employment has been terminated, is not to the exclusion of all. Part 6 stipulates that if an employee is re-employed 12 weeks after termination, or in the case of an apprentice 52 weeks after dismissal, then LSL continues to accrue. It's a very specific scenario that's unrealistic if the worker is dismissed due to incapacity. An employer would not sack an injured worker then rehire the worker who's still incapacitated and cannot work 12 weeks later. It would not make any sense to apply Part 6 to a situation involving an injured worker. My concern. Section 12 Part 4. An employee's employment is taken to be continuous despite an absence from work caused by the employer terminating or interrupting the employment with the intention of avoiding an obligation in relation to long service leave. In the case where an employer sacks an injured worker and refuses to allow the employee to accrue LSL beyond employment, this section by definition would apply. Those are the facts. The employer's reason to deny the accrual LSL is because they have been sacked. The employer has avoided paying LSL by dismissing them. This is all good and well if the employer sees that Part 4 becomes applicable and the injured worker continues to accrue LSL. If the employer refuses to adhere to the legislation and the injured worker is left with no other option but pursue this in the Industrial Division of the Magistrates Court. Note, only after working out the cost of legal fees to do this equal less than the amount of LSL owed and they have the means to pay for a lawyer while they aren't working, unlikely. The magistrate rules in favor of the employee and orders the employer to pay LSL entitlements out and rules the $10,000 max civil penalty be paid to the worker as well. How would this affect any legal proceedings brought against employers in relation to the injured worker's termination of employment? For example, adverse action, unfair dismissal or O&S and discrimination. Would a ruling under Part 4 put a stop to these actions because a court determined it was the avoidance of paying LSL that was the reason for the dismissal? The max civil remedy is $10,000 as opposed to what's awarded when an injured worker wins the other cases mentioned. A particularly cunning employer could take advantage of this opportunity to pay a much smaller penalty to the worker they have discriminated against and illegally sacked by way of Part 4. You'd like to think they wouldn't, but if you leave the door open, an employer is bound to walk through it at some stage. I contacted the ALRC, Australian Law Reform Commission, about this possible loophole. They suggested I refer it to the Attorney General's office for consideration. I haven't done that yet, but it's something else worth mentioning. Click the